Practically all of London's art world had crammed itself into the cramped, hot courtroom on November 25th, 1878. The afternoon light was falling fast, and candles were quickly brought in, illuminating the array of women in elaborate hats. Hats that the press noted, quote, formed an aesthetically harmonious pattern, end quote. Hats that the press seemed to understand better than the trial they were there to witness. The case was Whistler v. Ruskin, the painter James McNeill Whistler against the art critic John Ruskin. Ostensibly, it was a libel trial. Whistler was suing Ruskin over a review that had called him a fraud. But what was really at stake was so much greater. The future of art criticism, the definition of a finished painting, and the question of whether a painting even needed to look like anything at all. A question about abstraction. But in 1878, that didn't yet have a name. Two men who had never met, but who moved in overlapping London circles without once having been in the same room, would still not meet during this trial. But nevertheless, they would have their opinions on these questions tried before a jury of 12 people. And neither of them would be the same person at the end of the trial as they were at the beginning. I'm Emma Laramie, and this is Verso. To understand how Whistler and Ruskin ended up here, though, you need to go back a year and a half. Ruskin's own lawyer described him at trial as holding, quote, perhaps the highest position in Europe and America as an art critic, end quote. And for once, a lawyer was not exaggerating. John Ruskin had the kind of sway that could make or break a career. He had spent 30 years as the dominant critical voice in Britain. He was the man who had championed J.M.W. Turner when almost nobody else would, and his condemnation could end careers just as decisively as it could make one. Ruskin believed deeply that art had a moral obligation to its audience, that labor was the measure of value, and that to judge a work was to judge its creator. In his framework, poverty of style reflected poverty of spirit. So for him, beauty was not a matter of taste, but of truth. For him, there was a right and a wrong. A painting had to demonstrate truthful beauty, sincere labor, and moral meaning. If it fell short on any of these counts, the failure wasn't merely aesthetic. It reflected on the character of the man who made it. Henry James once wrote in The Nation that the Victorian public had long made allowances for Ruskin's quote-unquote literary bad manners, that his contemporaries had suffered his criticism without complaining. And they did this because disagreeing with Ruskin publicly carried institutional costs that most people weren't willing to pay. He had never really been seriously contradicted by anyone whose opinion he respected. At the time, Ruskin was a professor at Oxford, but that merely paid the bills. He fed his soul, and he believed the soul of the working man, by writing his own periodical called Fors Clavigera. In it, he was free to write about whatever he so pleased, whether that was art or politics, or both in the same stroke. This was the case for the fateful review he published on July 2nd, 1877. Ruskin was in the middle of penning a larger article for Fors Clavigera, refuting the idea that money, not labor, was society's great motivator. While working on it, he attended an exhibition at the newly opened Grosvenor Gallery. And he hated it. He hated the lavishness of the upholstery, the way each artist had all of their works grouped together, which artists were placed next to which. But he especially hated a painting by James McNeill Whistler titled Nocturne in Black and Gold, The Falling Rocket. Back at his desk, Ruskin tacked on an overall negative review of the exhibition to his larger article, almost as a postscript. But he left the most scathing commentary for Whistler, saying, quote, "For Mr. Whistler's own sake, no less than for the protection of the purchaser, Sir Coutts Lindsay ought not to have admitted works into the gallery in which the ill-educated conceit of the artist so nearly approached the aspect of willful imposture. I have seen and heard much of Cockney impudence before now, but never expected to hear a coxcomb ask 200 guineas for flinging a pot of paint in the public's face." End quote. One note about Ruskin's state of mind that summer, which matters more than it might seem. He had spent recent months in Venice and had returned exhausted, feeling dizzy and lightheaded. He professed a growing conviction that the natural world was darkening, and he was exhibiting a deep sensitivity to light, particularly light that glittered in the darkness. So it is entirely possible that seeing Whistler's painting provoked all of his worst fears. It also may have been one of the first signs of a much more serious collapse to come, but whatever the case, he said it with his whole chest. James McNeill Whistler was nothing if not a character. By the summer of 1877, he was already enjoying a spate of notoriety thanks to a project he took upon himself that became known as the Peacock Room. The story tells you in a nutshell just about everything you need to know about Whistler's personality and self-confidence. One of his great patrons at the time was a man named Frederick Leyland, who had recently commissioned the architect Thomas Jekyll to design his dining room, where one of Whistler's paintings would hang with pride of place. The project was nearly complete when Leyland asked Whistler for his advice on paint colors for the shutters and the doors. Concerned that Jekyll's dining room would not sit harmoniously with the colors of his painting, he got permission from Leyland to make a few minor alterations. Or so Leyland thought. When Leyland left the city for the summer, Whistler pounced. He painted gold peacocks on the shutters, gilded the shelving, covered the ceiling with Dutch metal leaf overlaid with a blue peacock feather motif, and he painted the leather blue. He went so far as to title the dining room, Harmony in Blue and Gold, the Peacock Room, sign his name in 4 different places, and invite the press into Leyland's home to admire it, all without his permission. Naturally, Leyland was furious. But it had the added effect of cementing Whistler's reputation as a great colorist and designer, making him something of a local celebrity. It also showed him the importance of publicity, something he would take to heart. This story is in many ways the story of Whistler's whole life. He had started out as a West Point cadet and been discharged after 3 years for being, quote-unquote, unsuited to discipline. He moved to Paris, then London, and grown increasingly dissatisfied with painting modern life. He was done with realism and had replaced it with art for art's sake. He began choosing subjects so far removed from daily Victorian life that his audiences would be forced to not take them literally, something that was nearly impossible for them to do. This was how his nocturne paintings came to be. Having always lived near the Thames, he would stroll its banks in the evening, and in the 1870s, seeing it anew through the influence of Japanese printmaking, he began to see the poetry of the river at night, when the atrocities of the industrial world were less apparent. So he painted just that, but in a way that wouldn't make it immediately obvious what the viewer was looking at. The whole thing was an affront to conventional Victorian ideas of painting. It was a modern, sensational, ephemeral, and indescribable spectacle, of nighttime no less, without a trace of morality in it. Ruskin was not the only one who was shocked by it, although Whistler was in no jeopardy of being cast out of society for it. He was, however, in jeopardy of losing all of his money. Whistler had been living beyond his means for many years by the summer of 1877, and only 2 days before he learned of Ruskin's scathing review, the sheriff had sent a bailiff to his house to collect payment of his debts. Debts that he couldn't repay. So, although his reasons for suing Ruskin were complex, the money he could fetch by winning a libel lawsuit undoubtedly flashed before his mind when he was sitting smoking at the Arts Club with his friend George H. Boughton, as Boughton hesitantly read him the excerpt. According to Boughton, Whistler's face was unforgettable, furious and sad at the same time. When Boughton suggested that the review could be libelous, Whistler merely replied, quote, "That I shall try to find out," end quote, before smoking his cigarette and leaving. The suit was underway within the week, and Ruskin was served on August 8, 1877, exactly 1 week after the exhibition closed. Despite the speed at which the suit was launched, it would be a long time before the trial actually took place. That was due primarily to Ruskin, whose mental health had deteriorated further by January 1878. Throughout that winter, he claimed he was visited by Saint Ursula and other young lady saints, suffering from quote-unquote strayed wits. His mental health struggles were real, but so was his disdain for the entire proceeding. As he put it, quote, "The professor of medicine might just as well be brought into court for denouncing an apothecary who watered his drugs as the professor of art for denouncing an ill-finished picture," end quote. But even still, he couldn't help himself, and he prepared a lengthy, thought-out memorandum of instructions for his lawyers that he anticipated they would use for his defense. His idealism was commendable but ultimately ill-placed. His lawyers knew before the trial even started that they would lose. All they were concerned about was making sure Whistler's damages seemed ridiculous. In this, they would succeed. Whistler was equally confident in his position, believing wholeheartedly that all of London's art scene would come to his aid. It was another example of his confidence living larger than reality called for. Whether or not they agreed with him, most people were too afraid to go up against Ruskin. His influence was that great. Some people refused to appear from the jump. Others agreed only to bail 2 days before the trial. Some agreed to write their views down, which was useless as evidence. So when the trial finally got going in November of 1878, he had only one ally he could rely on: the painter Albert Moore. Back in that hot, candlelit room, the defense's lead counsel was Sir John Holker, the Attorney General of England, described by one observer as producing, quote, "the impression of a giant talking in his sleep," end quote. His brief was not to win. It was to make Whistler look so ridiculous that the jury would award contemptuous damages. So he presented himself as a plain, baffled Englishman, bewildered by incomprehensible art, despite having privately commissioned a painting from one of Whistler's old friends. The plain man routine was calculated, and it would prove more effective than anything Whistler did on the stand. But took the stand Whistler did. Holker, Ruskin's lead counsel, asked how long it had taken Whistler to, quote-unquote, knock off the nocturne. Whistler reportedly replied, "I beg your pardon?" Holker clarified that the expression was, quote, "rather more applicable to my own profession," end quote. Whistler then responded, "Thank you for the compliment." The audience was already laughing. The exchange that would go on to define the trial came shortly afterwards. Holker pressed Whistler. The labor of 2 days? Is that what justified 200 guineas? Whistler paused. In his own later account, which we do have to take with a grain of salt, he replied, quote, "No, I ask it for the knowledge of a lifetime," end quote. The room erupted with applause, and the judge cut it off, quote, "This is not an arena for applause," end quote. And this was the problem for Ruskin's legal team. Whistler was performing magnificently, and the legal process could not afford for everyone to keep watching him perform. He also described his paintings in terms that were philosophically coherent. The Nocturne wasn't just a view of Cremorne. If you wanted a view, you would only be disappointed. It was an artistic arrangement. The figures on the bridge were, quote-unquote, just what you like. The painting might represent everything he intended, or it might represent nothing. He was articulating abstraction before abstraction really had a name, before anyone in that room had the vocabulary to understand what he was actually describing. The closest word available was eccentric, and in that courtroom, it was treated like an insult. But his paintings themselves, which were brought into the courtroom as evidence, were not cooperating. They were allegedly passed through the audience, held upside down and misidentified. There was another nocturne depicting the Battersea Bridge that was supposedly explained to the jury by the judge himself as depicting Old Chelsea Church. And Whistler, asked whether a particular canvas was his, inserted his monocle, paused, and replied, quote, "Well, it was once, but it won't be much longer if it goes on in that way," end quote. The best thing Whistler had was the painter Albert Moore. Moore was quiet, shy, and constitutionally averse to spectacle, but he had overcome all of that specifically to stand up for his friend. He has painted the air, Moore told the court, which very few artists have attempted. On the price, he said, quote, "The money is paid for the skill of the artist, not always for the amount of labor expended. If I were rich, I would buy Mr. Whistler's pictures myself," end quote. And when asked whether the paintings were eccentric, he said, quote, "I should call it originality. What would you call eccentricity in a picture?" End quote. He was the most intellectually rigorous person in that room, and almost nobody cared. Then came the pre-Raphaelite painter Edward Burne-Jones, who had also exhibited at the Grosvenor Gallery exhibition and had been praised in Ruskin's review. Burne-Jones had spent the weeks before the trial writing privately that Whistler was, quote, "scarcely regarded as a serious person," end quote, and was building a, quote-unquote, "school of incapacity." But he didn't have nearly the conviction Ruskin had to say what he really felt out in the open. On the stand, all of that dissolved. He admitted the nocturnes had fine color and atmosphere, even as he condemned them for lacking composition. He went home feeling ill and miserable and sleepless, and sent Ruskin a quarter of a halfpenny stamp by way of apology. When it came time to deliberate, the only question the jury asked was essentially the whole trial distilled into a single sentence. Was Ruskin's language in his review a reference to Whistler the artist or Whistler the man? After nearly 2 hours of deliberation, the verdict came down. Ruskin lost, but it was not a total victory for Whistler. His reward? 1 farthing. Hardly the 200 guineas he had hoped to get for Nocturne in Black and Gold. But ever the spin doctor, Whistler was quick to turn the situation around from a laughable embarrassment into something grander than it was in reality. "It's a great triumph. Tell everybody it is a great triumph," he told a journalist. The press interpreted the result in every possible direction at once. Some said Whistler won, some said Ruskin won. The Examiner called it a, quote, victory which bears a very striking resemblance to a defeat, end quote. They were all, in their own way, correct. In The Gentle Art of Making Enemies, the book Whistler published in 1890, in which he curated his own legend for posterity, the verdict occupies exactly 1 page. The entire text reads, quote, verdict for plaintiff, damages 1 farthing, end quote. Ruskin received the news of the verdict at his home, delivered by a friend who had traveled through a snowstorm to reach him. His response was, quote, comic enough, the whole trial, the public may think, but I'll make them remember it, or my name's not mine, end quote. 3 days later, he wrote to Oxford to resign from his professorship, citing the verdict as the reason. The verdict had not legally compelled him to do anything. He was using it as the occasion for a departure he had already been contemplating. But he would come to believe, genuinely and completely, that the law had silenced him, that the public had been robbed of his guidance. He turned his loss into an abdication. So Whistler had won his 1 farthing, but the legal costs of a trial he technically won pushed him into bankruptcy 6 months later. He had thought he would get something like £1,000 and had expected to clear his name and his debts. But all of that had been replaced by a coin worth less than a penny. The lawsuit he had filed to save himself had done the opposite. By May of 1879, the creditors had closed in. Wine merchants, cheesemakers, coal merchants, bootmakers, seed growers, the debt came to £4,500. Bailiffs took possession of the White House, the home Whistler had built on Tite Street to embody his aesthetic principles, and sold it to a critic he despised. He left for Venice on the evening the house changed hands. His plan was a modest one. Produce 12 etchings that had been commissioned by the Fine Arts Society for a fixed fee, just enough to begin paying off what he owed. Venice was not what he had hoped at first. The winter of 1879 was the coldest the city had seen in 30 years. He hated the food and he pined for Pall Mall. His fingers were too cold to hold the etching needle, and the plates would freeze. He was working through the obvious subjects, the Grand Canal, the famous panoramas, but he was finding himself dissatisfied. Then, at the end of January 1880, something shifted. He found the narrow neighborhood canals, the strange bits of architecture in the quieter parts of the city, subjects no one had thought to paint. And he developed a new staccato style, dots and dashes that were nearly calligraphic, scenes structured as geometric patterns, squares and rectangles where other painters were depicting doors and windows. He began experimenting with pastels on plain brown paper, the same paper that had been used to print his Whistler v. Ruskin pamphlet, leaving most of the earth tone visible, adding only touches of white and a few simple colors. He ended up producing 50 etchings when he had only been commissioned for 12. When the exhibition of these works opened in London in January 1881, over 42,000 people came. Critics talked about the triumph of tone and mastery of effect. The pre-Raphaelite painter John Everett Millais stood before the work and declared loudly, quote, very cheeky, but fine, end quote. Whistler had gone to Venice to survive. He came back having made the finest work of his career. In 1892, Nocturne in Black and Gold finally sold, 14 years after the trial, to an American collector for 800 guineas. Ruskin was still alive to see it, and Whistler wrote, quote, the pot of paint flung into the face of the British public for 200 guineas has now sold for 4 pots of paint, and Ruskin has lived to see it, end quote. Ruskin spent his final years at his estate in near silence, writing an autobiography that was gentle and nostalgic and nothing like the ferocity of Forrest Clavigera. He didn't finish it. And he never conceded anything. The painting the jury couldn't make sense of in that hot candlelit room is now in the Detroit Institute of Arts, considered one of the most important paintings of Whistler's career. And the word the courtroom didn't have, abstraction, would go on to define an entire century of art. Whistler filed this suit expecting to save himself and got 1 farthing for it. It was the most expensive thing that had ever happened to him. It was also, eventually, the best. This episode was written, narrated, and produced by me, Emma Laramie. If you enjoyed this story, if something here surprised you, made you think differently, or just gave you something interesting to talk about over drinks with friends, do me a favor. Follow the show. Leave a rating or a review if you're feeling generous. And if there's an artist or a moment in art history you're curious about, drop a comment below. Thanks for listening. I'll see you next time.